Okay, guys, let's get right into this video, but please remember to like, subscribe, and click the all button. Let's get right into it. Here are 5 questions that disability judges will ask more aggressively. Now, what do I mean by that? They will change the tone of their voice. They will change the speed at which they are asking that question. They will have that slightly aggressive tone that makes a lot of claimants nervous and have to rethink what they actually want the answer to be for the question and answer that they're going to be delivering, okay? So please remember with all this, hit the like button. Let's get right into it. Disabilities judges, they ask these questions aggressively because there's often evidence in the record that the judge knows the claimant does not want to share or offer willingly. And so the judge also knows that the claimants are trained by the attorneys to pivot when these topics come up, which is why judges will use derailing tactics to get the information out of the claimant. One of those derailing tactics is using, essentially, a harsher tone. Now, a federal judge with a harsher tone is a very effective tool with most people. And consider that as we go into the first question. Think about it. Think about how I change the tone of my voice. And imagine it's a federal judge that's sitting in front of you. So here's the thing. Now, a quick side note. Some of the viewers received their benefits back in the day, okay? And never had to go in front of a judge. And so I've noticed comments where they're like, oh, I never had to go in front of a judge. Well, I just got my benefits in 2 months and da-da-da-da. So I just want people to be aware or mindful of the fact that not everybody was so lucky as you. And also the people who are applying nowadays don't live in that world. They live in a totally different program. The program takes significantly longer to be found disabled. And it's flat out, the rules have changed, more difficult to be found disabled. So the point is, when somebody in the comments, just be a little considerate, be a little sensitive, because there's some people who have been fighting for years and years. And then you come in and you're like, I was found disabled yesterday and I applied the day before, right? So just be aware, like, those individuals look at that and they're like, what the heck? And it creates this negative, like it's unfair to me and it's da-da-da-da-da. There are adjudicators that will pass one person through and the other person will be denied. There are situations where sometimes something in the record will be overlooked that would kill a claim. And other times it's front and center and it is the thing that they're using to end the claim. So I just want to make you aware of that before we go forward, so that, the people who have this, like the ego, the presence of the ego, that they kind of cool it a little bit, because some of these individuals are literally homeless sitting there going, wow, my life is miserable. And these other individuals typing into the thing are like, oh, I got my benefits in a day. I got them yesterday. I got them, 48 hours, took no time, blah, blah, blah. Never had to do this, never had to do that, yada, yada. And the truth is, some claimants have easier disabilities to be found disabled. Some of them, the way they the requirements to be found disabled, the elements are far easier than other impairments. But that's for another video. Let's get right into this real quick. The classic question that judges always ask, or start with asking a little bit more aggressively, is that basically, and it's the classic. We always hear this one. It's always at the top of the list. So how many beers do you drink in a day? Now, this question, I'm going to sum it up real quick because we've covered it before. The judge will ask, okay, how many beers do you drink in a week? About 5. And then they'll ask, okay, how many beers did you have 2 days ago? I had about 3 beers. What about yesterday? I had about 1 beer. Oh, let's go back to the weekend. How many beers do you have on Saturday? Well, I had about 5 beers. How many beers do you have on Sunday? I had about 2 beers. All of a sudden, in a week's period, we're way beyond what you said you drank in a single week, which then on record creates a scenario where, to be fair, you are being disingenuous. Even though you're trying to tell the truth, you've just created a statement that you've just disproved. So this question is one of those things where a lot of claimants, they get stuck. They get stuck because they don't realize what's going on. It is the most classic Social Security disability trick question. It is like, if you wanted to know like the origin story of disability judge, like, trick questions, that would be the beginning point. Okay. Now, the next one is this. If you knew that you needed treatment, why didn't you seek it? Right. So phrasing it again, if you knew that you needed treatment, why didn't you seek it? Right. So let me understand this. If you knew that you needed the treatment, why didn't you seek it? Right. That little bit of aggressive tone will put a claimant on their heels? Let's go through it. This question is a lot of things, but mostly a perceived severity analysis question that the judge is using against the claimant that's sitting before them. If someone is bad enough, like severe enough, like their impairments are really painful, or they're just restricting them in absolutely, terrible ways, then what will happen is they will crawl towards the ambulance. They will crawl towards the hospital to get treatment. If someone is not that bad, they will make choices related to their sentiment. Like, meh, I'll go to the doctor next month. Or, meh, I don't want another emergency bill, right? These are all statements of people who truly aren't that severe. Because if they were that severe, they would have to go ahead and make those motions and make that effort to try and get into a medical facility. Okay. Now, you're also going to see comments that'll pop up in the chat or potentially in the comments section after the video where people will be like, oh, what do they expect from us? I can do this and this and this, and I'm disabled. Please remember, when you were found disabled 7 years ago, 10 years ago, 15 years ago, 20 years ago, it was a different program. You were blessed to be found disabled when you were, because many of those people that are found disabled back in the day are getting kicked off of the benefit program now with an overpayment. I know this. I know this for certain because about half to actually more than half of the questions we get every single day at the law firm are from people who are kicked off their benefits due to lack of severity. So just remember, for those with the ego out there, I'll probably get your call at some point. So just, be aware that it's not the same program. Although those who were found disabled back in the day, they have rules to protect them because the rules of disability back in the day are applied to them going forward. But still, the culture of the SSA has changed, which is a much bigger video, which does hurt those individuals in the long run. All right, let's go through this real quick. So the judge is really asking you with that question, once again, if you knew you needed treatment, why didn't you seek it? The judge is really asking you where your perceived emergency for medical treatment is. Do you perceive yourself as somebody who is in dire need, who is in critical need of medical treatment? This is important because pain tends to be subjective, along with many other symptoms that result from an impairment. For this reason, they are asking you whether you were in dire need or someone who just sat at home and dealt with the pains or problems. There are a lot of people who just sit at home and they deal with it. It's just a fair comment. It is what it is. Okay. Those people have choices, and their choice, for whatever reason it may be, makes them appear to be less severe than someone who needed medical treatment. Okay. And basically had to go in for an emergency medical review, and many of them on a repetitive basis. So the point of that question is to check the claimant's perceived understanding as to how severe they actually are. Now, here's the deal when it comes to the like button. If you don't hit the like button, we only have 37 likes. We only have 37 likes of 115 people in the room. If you hit the like button and use your like finger, that helps the video. Make sure you don't be stingy with the like button. All right, next question. Why didn't you follow the direction of your physician? Okay. Now, this question can be very tricky and very problematic. Let's go through the ideas here. All right. You have some choices when answering this question. A, it's my body and it's my choice, right? You hear that one, you're giving too much, flack to the judge. That's not good. B, oh, I know my body and I know what it feels like on the inside and I know what's right for it, right? So you're telling the judge you didn't follow what the direction of the physician was because you know your body. Option C is that, the side effects were too horrible to continue with the treatment. Okay. Well, then the judge is sitting there. All right. Why didn't you try alternative medication? Why isn't there any notation inside the file about you having problems with the medication and then trying something else, or even notifying the medical expert, right? The one that you were seeing, the person that you were going to for medical treatment, why you didn't tell them in the first place? Option D is that the doctor was wrong, right? So I'll go back to the question again. Why didn't you follow the direction of your physician? Now, some people will go with the following one, that the doctor was wrong because of these options. Let me read through them so that you have them. Number one, well, the doctor was wrong because their medical treatment was too experimental, or it wasn't experimental enough, or it wasn't that I wanted what I wanted based on my own online research, or it was causing me to get worse, or I got a second opinion that countered the medical plan that I was on or receiving. or I felt like I couldn't financially keep up with treatment, or my insurance stopped covering me and I had no more options, or I lost touch with what was best for me because of my mental issues, or I took bad advice from others, or I made poor choices because of a bad boyfriend or girlfriend or medication cocktail, or I often sabotage my own success because of mental issues. Those are a bunch of options that claimants will traditionally take with this question of why didn't you follow the direction of your physician? At the end of the day, what the judge is getting at is you had medical treatment. The doctor had you on a plan. You chose for some reason, whether from action or omission to act, right? You chose to get off of what was recommended. Because the problem with that is that the judge then can't say, well, the medical doctor's opinion is valid because you followed what the procedure was, and the result of that procedure was you, in this instance, at that medical level. But when you stop doing what they tell you to do, and I'm not saying, you shouldn't, there might be a valid excuse in there. But when you stop doing what the doctor stated, had you on the plan to do, then the judge doesn't have solid footing to say that that doctor's record should count in any way. Because at the end of the day, the bottom line is that that doctor's record has basically a non compliant patient. And when you do that to the doctor and become that non compliant patient, you basically ruin that doctor's ability to have good weight as evidence. Let's go to the next question. When you boil it down, though, sorry. So the next one is this over here. Let's go over to this. Hold on. Okay. Why did you wait so long to go into rehab? I hate this question. When this question comes up, it's miserable because there's no perfect answer. There's no good way to attack this. In the sense of the claimant, the hopeful beneficiary sitting there and being like, "Whoa, Your Honor, there's no good way to really, go at this thing without, destroying the ego of the claimant in the process." I'm going to explain it real quick. All right, judges get to sit atop their wooden box, right? And see the whole timeline. It's like their soapbox. They get to look at the whole file. They get to judge on it. Why did they make these mistakes? Why didn't they do this here? Why didn't they do that there, etc. Now, this gives them an advantage as a judge, but it also, from the perspective of someone who doesn't live, as a judge would, anywhere near that poverty level. So you have these like creatures, these demigods, right, who are judging people. They don't really know poverty. They've never been towards that poverty. Maybe when they were much, much younger, they did, but they've been in a position of working and getting educated. Because remember, to be a judge, you have to pretty much be a lawyer. To be a lawyer, you have to go through all this academia process, and then you get jobs to support all of your student loans and yada, yada. The point is, they don't have a strong, understandable grasp on the poverty problems of America. Neither do the politicians, but judges, I think we could all agree, are a little bit more removed. And maybe there's one bright, shining star of a judge in every 1,000, right? But for the most part, the judges, they don't really grasp the whole poverty problem. Okay, so here's the deal. Bottom line is that when you have a problem, right, you don't usually realize how bad it is, especially when rehab is a consideration. We're talking about drugs, alcohol, narcotics, even tobacco related products are falling into that category now. Now, you are struggling to hold on to, as a person that has a problem, the little bits of your life that you still have. And going into a program means basically all your photos and paperwork and connections and good and bad that you have going on in your life to keep that little bit of your thing going, to keep that little bit of thing that you think is you. Well, all that goes in the trash bin. It's all gone. By the time you get out, somebody will have grabbed it, stolen it. It got wet. It was in the rain. Somebody didn't push it under the double wide trailer, whatever. All of your history in that bin that you left someplace gets destroyed. That's how it works. Most judges, they don't understand that. They're never going to understand that because why would they? Let's just be fair towards the judges here. Why would they understand that? Okay. So people don't get the help they need when they need it because they are trying to just make their life work as it is, right? Where they put themselves, they're trying to climb their way out or just keep it going the way it is. And usually with that situation, you get to a point where it's not working and you keep sliding backwards and backwards and backwards and backwards. Now, how you fix that situation is a whole other video unto itself. But when it comes to this question, ultimately, the best answer that I've ever heard, and this is important, it's important, and I hope you listen to it, is to apologize to the judge. Literally, quite literally. Some of you will have an ego that will totally disagree with that. Thank you, Shirley. Thank you for the nice haircut. So I have the military style haircut. I get it cut this way because I get to save like an extra 2 weeks off of getting another haircut. Thank you for the $9.99. Also, if I scroll up a little bit, I really love that. Diana Fernandez, thank you for the $2 donation. The Howdy Handsome before the video even started. Guys, please remember to continue to click that like button and hit the subscribe all. We're going to keep rolling through here. But again, ultimately, the best answer that I've ever heard when it comes to dealing with this question is to apologize to the judge. I have clients who will de facto never apologize to the judge. They've got this ego and they've got to protect their ego because their ego is so important to their life and it's who they are. You get a lot of that. Okay. You get a lot of that from low income areas where it's the only thing they can hold on to. You get a lot of that from the VA individuals who are in like the really combative versions of the, sections of the VA, or rather in that case, the military. And they're protecting the identity of who they were, And I get it. I really do get it because that's who they are. That's like the thing that they protect. That's the walls that they put up so that they keep others out who can't get in and harm them. So I get it. I really, really do. Now, sounds weird to apologize for something like that. Might sound wrong to some people, but it's the absolute best thing you can do. Saying, Your Honor, I'm sorry. I made mistakes. I'm making right choices now. And I have these things helping me make the right choices. And I'm moving ever so slightly in the right direction every single day. I have little wins. The little wins are adding up. That is how you approach that question. That is how you deal with that situation. Or you could tell the judge, let's go back to the question, why did you wait so long to get into rehab? Or you could tell the judge that you were busy. Or you could do that. You could totally F your claim and you could just, you were busy. Or my personal favorite, which actually I had 2 claimants do this, was where the claimant replied, well, it's none of your business to the judge, which I thought was saucy, sassy, and a few more S words. So anyways, let's go on to the next question. Here we go. If you purely didn't like your job, why didn't you find positions in alternative industries? Oh. So now the judge is going, hey, wait. If you didn't like your job, go get a different job. If you couldn't do that job, why didn't you try to find another job? So many times I represent claimants. Okay. I tell them what the problems are up front. We revisit in the middle. We revisit again. Then we get to the hearing, right? The hearing stage. And I say to them, look, you've been apply for jobs. And they'll come back and say, no, I can't work. And then, of course, I say to them, well, how do you know that? Oh, because I know I can't work. And that's part of the building process. We have to destroy their ego to get them to the point where they can rebuild their ability to answer questions that a judge will ask them. And then I say, well, how do you know that you can't? Oh, because I'm in my body. I know I can't work any other jobs. Well, how am I supposed to know? Oh, the medical record says it. Okay. But then and this is where it all breaks up. Then I say to him, okay. But if the medical record says you're bad and we have no additional proof of you attempting it, then how can we be sure? Oh, because the medical record said that. And that's when I looked at him and I say, well, assuming the judge isn't going to just literally sit up and applaud that argument, sit up and say, well, de facto, of course, and that's where I get real with the claimant. I say, look, if the claimant's completely blind, sure. But there are people who are blind that still work. And then they go, oh, that's true. Okay. Yeah. And then I say to them, now look, sure. If you had lost your leg and half your hip, sure. Absolutely. Couldn't work. But there are people who work without a leg and half their hip. Oh, wow. Oh, man. Yeah. And I say, there are even people who work that don't even have any hands. There are even people who work who don't have any feet. Oh, yeah. Okay. All right. So what do we do? And I said, well, what the judge is looking for is somewhere in the transition away from your career-oriented jobs that you basically attempted to work something else. I don't care if you get fired the first day. I don't care if you get fired the first month. I don't care if you get fired within the first 3 months. But they're looking for attempts in the market of work. Okay, cool. So let's talk about the two types of people that we usually come across this question. I'll read the question again. Here we go. Okay, here we go. If you purely didn't like your job, why didn't you find positions in alternative industries? Okay. The first person will try to toe and toe with the judge. Well, Your Honor, I was trained for this and I was educated for that. I was experienced for this. And it would be a downgrade to go ahead and go and do a job that's less than that position. This person also doesn't know that the standard for disability benefits, just to be clear, they don't understand, they don't know that the standard for disability benefits is not whether they can do, okay, their past work. Whoa, Wild Family, 1996. Huge donation there. Wow. Thank you. $49.99 donation from Wild Family, 1996. Really appreciate that. That's amazing. Thank you. That's so awesome, guys. Thank you so much. Seriously, that's amazing. So the point here with this individual is that this person will try to go toe to toe with the administrative law judge, which is weird because it's like you're sitting in front of a demigod who has complete power and total control over whether or not you're going to be found disabled. So why you would try and go toe to toe with them is just, weird. Just so you guys know, the purpose of going in front of an administrative law judge is to help do their job for them so that they can more easily find you disabled. It is not to attack and piss them off. I know some of you feel that that is a great strategy. I've never seen it work very well. I've been doing a lot of hearings, but I could, of course, be wrong. I could be wrong, but I have always found that when you do a section of the judge's job to make it easier so that they can approve the claimant, that the claim goes much smoother. Okay. So this person also doesn't usually know that the standards of disability are, can you do your past work? Cool. Element 4, no, you can't. But then there's this element 5. The fifth element is what gets them in. It's what's the cleaver. Okay. The question is, what other types of jobs in the national economy, okay, exist that this person could potentially do? That's element 5. It's the cleaver. It's an abusive element. It really is. I've lost claims due to element 5 more than any other element. Okay. So, the bottom line is this: they don't want to downgrade what they were doing. And yes, the SSA does expect you to downgrade jobs, downgrade industries, go to some other job or place or whatever. Whoa. Oh, yeah. The railroad retirement video. Okay, Wild Family, 1996. There's that. Yeah, so I have to do that. You got to email me because I started that script and I never got everything fully done there. And I remember that too because that had to do with the blind video with the same terminology that's used for that. So Wild Family, email me tomorrow so I can go ahead and finish that up. And then we'll just do it. We'll do it over the weekend. We'll just get it done. But super thank you, good sir. I really appreciate it. Okay, so the thing is this. When it comes to basically, when it comes to this situation, the judge will go ahead and look at this and say, okay. Are you able to work a lesser job? Now, some claimants that don't have attorneys, they'll say, yeah, probably, blah, 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 blah. Cool, that's a claim killer, right? Some will say, no, I can't work any job. There's no job, blah, 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 blah. And then the judge will say, okay, well, how do you know that? And then the claimant is sitting there going, well, it's in my medical record. And then the judge goes, well, assuming that, the medical records show that you were impaired, but how have you tried? What vocational path have you attempted? You stopped working and then you didn't try anything else. So my point with this, okay, and you have to understand, the more education you have, the more difficult it is to be found disabled because the higher level SVPs that they give you, when doing the element 5 adjudication, and also the more transferable possible skills you have. So what you have to understand is going toe to toe with the judges when they give you some snippiness, right? Some general snippiness with this question that if you purely didn't like your job, why didn't you find positions in alternative industries? They give snippiness here because they're tired of hearing all day long that a claimant knew they were disabled, when it's really the judge's job to figure out if they are disabled. And then, of course, the judge can always fall back on, well, I'm not the one who defines that. Purely this commissioner of the SSA does. But that's a whole, I'll do a different video on that. That's a funny thing. All right. Now, there is the second person to this question, the non-egotistical, non-aggressive person. Okay. What happens with this person? The second person selling the severity of their impairments will explain how their impairments limit their ability in any field to do work. Okay. This is the chicken dinner winner of the two options. The person who goes ahead and hopefully has in the past attempted work that they failed and got fired at, and also can explain why their impairments limit their functions to do basic jobs. That's the winner. So they're able to talk about past work. They're able to talk about essentially the functions. So they get to work, what do they do? Then after that, what do they do? And then after that, what do they do? They get to the end of the day. What's the last thing they did at the end of the day? Those are the functions, okay, of those jobs they had. They talk about how their impairments limited those functions, and then they explain why simpler jobs or even part-time jobs would not work as well. This person knows how to speak about basically the breakdown, okay? Old school truck driver, thank you for the $10 donation. I super duper appreciate it. That's awesome. Very, very awesome. Very, very cool. Okay, so the thing is this person knows how to break down what they did when they first got to work, what they did right before they left. This person knows how to explain the symptoms and the limitations of their impairments and how the functions become so limited that they are inherently precluded from work. Be person 2 in this situation. Do not be person 1. Getting into an egotistical battle with the judge is never going to come out well. I have won claims where the claimant was egotistical with the judge, but I can assure you, out of those claims that I've had where the claimant was egotistical and basically, was egotistical that I won versus egotistical that I didn't win, I lose more claims when the claimant is egotistical. So when a claimant says to me right up front, well, I'm going to give that judge a part of my mind, that is a very good example of a claimant that you don't want because they don't understand the power scenario. The power scenario is that the judge has all the power and the claimant sitting there starving and unhappy and miserable and about to become homeless or already homeless, you guessed it, has no power. They don't. All they can do is practice their craft, get better at answering the questions, get better at delivering the testimony that they need to their medical doctors to write down the notes that, give the best shot of ticking off those little boxes required by the judge. Mastering their craft. That's why I always say with disability law that it's, when people go with like the really, really big box firms and they're like, oh, the attorney just handles everything. And I don't know. I haven't talked to them or whatever. Like there's clients that want you to basically just handle everything and they don't want to be bothered. Those claimants are great for big box firms. Then you have claimants who won't fill out forms. They're like, oh, well, I had one recently that I had to terminate. I just fired him. And the bottom line was he's like, I'm not going to fill out this form. I filled out this form, or he thought he filled out the form. He actually filled out something different. And then we went to a federal level hearing, and the individual basically wouldn't fill out some of the required forms that the judge was going to be sending out that we sent to him ahead of time. And so at that point, I was just like, you know what, dude, I don't need it. And here's why. If claimants aren't willing to participate in the process of building it to be better, then why the hell did they hire me? Like they could just file a form, sit there and hope that shit will go in the right direction, right? That the wind will pick up and sail them into glory. But I think most people, especially nowadays, realize that those days are over. The days of like, I got a super high passage rate judge. Yes. Those days, they're over, okay? Most of those individuals, those super high percent passage rate judges, they retired during COVID or they passed away. Many of the judges that I used to consider to be very high percent passage rate judges, many of them passed away. I'm going to tell you a quick side story, then we're going to get to the video where I answer questions. There was a judge, it was my first hearing with him, I don't know, maybe it's like 8 or 9 years ago. But the point is, he asked me to stay after the hearing. I'm thinking, oh, Christ, I'm in trouble. I'm in real trouble now, right? So the claimant leaves the room. I sit back down, after I open the door for the claimant. Claimant walks out, blah, blah, blah. And so here's what happens. So here's what happened. He goes into a monologue about how problematic the government is, how disillusioned people are with the government, and how disillusioned the employees in the government are with the government. He goes into a speech explaining to me why he's so unhappy with how the government is doing. And he goes into this, explanation under the basis of, in his early sentences, where he had basically been on almost every court as a judge. And I believed him and then I looked it up and it was true. But he had been on so many courts, and his retirement path was a disability judge. What I learned from that moment, and just, the point of his, like, what he was telling me was that when people get hired and then basically promoted in the government, it's not like the real world. It's not like in the wild with private industry where, like, the best person gets promoted for the job. That sometimes it doesn't happen in private, but in the private industry, usually the best person gets promoted for the job. But in government jobs, usually the person who's been there the longest, or there's some aspect of them, maybe it's a skin color, maybe it's where they're from, like they could be from Brazil and then they came here and there's a story that backs like their triumph, and now they work for the government, and the bottom line is they get promoted as a result of national identity, where they came from, their tough story to where they are now. So what happens is people get promoted for what he believed to be the wrong reason, which allowed a lot of individuals to be in managerial positions that should not be there because they didn't have management skills. Now, the government has gotten way better about this since then because they've been doing more management skill courses, more, how to achieve this, how to do this better, how to think like this. They're doing what the private industry people would like pay to do, to go like become a better leader, how to manage tough, employees. They're learning how to do that. So they're training their people better. But I'll never forget when it came to that judge, what was behind all of those terms, what was behind all of those phrases. What it was this sad, given up, it's never going to get better, it's never going to be what it should be. And I think that the reality was this. I don't think that judge was very happy with his clerk that was assigned to him. And I don't think he was happy with the clerk because the clerk, to be honest, was a bit aloof when it comes to processing claims and doing stuff in a timely manner, et cetera, et cetera. So I don't think he was happy with that clerk. And I think that was a main factor. But I think also, and I think this is important, at the end of the day, most people are not born to be Napoleons, right? These great leaders and da da da. And I mean, obviously he did horrific things, but you get it, right? The man, you could literally put him in a room and he would take over the room within so many hours, right? So the point is, I think America, when it comes to the government, had to become better at reshaping its employees to go ahead and take those steps to become better leaders. Now, with that said, I think government jobs, for most like administrative functions, like what the SSA has, does not tend to attract really great leaders. If you're talking about government jobs and great leaders, you're going to look at politicians. And even then, I don't know how much of a great leader we can say they are. They're just, look, politicians are failed attorneys, okay, who very simply put are not handsome or beautiful enough to work in Hollywood because they're great actors and actresses. They just don't have the look required to play that part. Now, what I think is really important to understand with these questions, and then we're going to go ahead and go to the video where I answer questions for people who call in. What I think is really important with these 5 questions, the disability questions, etc., is that at the end of the day, if a judge gets aggressive with you, realize that you've now seen behind the veil on what types of answers are going to be more effective against the snippiness. It is your duty to be a great leader in that hearing room or via video teleconference, telephonic, whatever, however you're doing it, so that you know ahead of time when the judge gets angry with you to center yourself, think about a good answer, and then deliver it with certainty. Because at the end of the day, we have these hearings because it's a chance for the judge to ask you questions where you will invest your knowledge, words, experience in their little transcript, which is a polite way of saying it's a chance for you to say something really stupid and for them to use that against you. So remember, when you get snippiness, take a moment. Thank you, Your Honor, for your question. I appreciate it. The reason, and let's go to the last one here. Let's just read through the questions in total. So how many beers do you drink in a day? Your Honor, thank you for the question. The answer is, if you knew that you needed treatment, why didn't you seek it? Your Honor, thank you for the question. I appreciate it. The answer is, why didn't you follow the direction of your physician? Your Honor, thank you for the question. I appreciate it. The answer is, why did you wait so long to get into rehab? Your Honor, thank you for the question. I really appreciate it. The answer is, if you purely didn't like your job, why didn't you find positions in alternative industries? Why didn't you get back to work? Why didn't you try? Your Honor, thank you for the question. I really appreciate it. The answer is, that is the best way to approach those. Because if you try to snip back at the judge, oh, good luck. There are few administrative law judges, and I'm going to quote a judge right now. It was an Orlando judge. I'm not going to say which one. She's one of the most neutral people when it comes to dealing with, and let me explain to you what she said. She said, when I approach, right, the group, right, you've almost always got a claimant and their attorney. Let me assure you, some judges dislike the claimant. Let me assure you, some judges dislike the attorney. But what she said was, you have to put these walls, you have to put them in these little boxes, and you have to consider what they're saying in their own little box and not allow bias to spread between these boxes. Okay? Very bright woman, very talented judge. But the bottom line is she always had an ability to give a neutral decision. I mean, I've literally seen my client yell at her, and she was able to, and that's me I was trying to calm the damn claimant down, but the claimant had reached saturation. Didn't take long, took about 20 minutes into the hearing, and the claimant had reached saturation. They had decided that they were no longer willing to be part of the process, which is weird because we had just started questions. But the point is, not every judge can do that, where they put everybody in their own little booth to not allow biases to move over. Because there is a definitive fact, and that is that judges, who are humans, like some claimants more than others, and like some attorneys more than others. All right, guys, I will catch you at the next video. Please remember to hit the like button. I want to do a super thank you. William, Wild Family 1996, email me. I already had 2 videos set up for tomorrow, but that's fine. I'm just going to swap one out and do your video because I had that script mostly finished up at this point. It was comparison based on the terminology used that's similar to that industry. I want to thank Shirley again for the $1.99 donation and also the larger donation. I want to ask Diana Fernandez. I want to thank her as well. The $2 donation. I want to thank, and I'm scrolling up here to there it is. Old School Truck Driver. Very cool. Thank you for the $10 donation. Remember, guys, if you like these videos, remember to like them. Click basically subscribe and all. What I love waking up to are those reviews. You go to Google, you type in Disability Resolution Law Firm, a Disability Resolution Florida. You leave a review. I can't tell you what review to leave because that's up to you. But basically, I love waking up to those 5 stars. Final note, if you want a disability attorney, you know who to call. You obviously know that I'm practicing, and that's a popular firm. But if I can't take your claim, don't have an emotional breakdown, and here's why. We are becoming more and more selective with the types of claims that we're taking, and here's why. We have 2 options as a law firm that is the most viewed and subscribed to disability attorney in America. We can A, take on tons of claims, tons and tons and tons of every claim that comes in, high take on. We could do that, right? Which means like we would be like, oh, okay, cool. We'll take all these claims and we'll have a lot more that we lose, but we'll make more money because we'll win more because we took on more claims. Or we could take on ones that we really are interested in, that we really want to win. And we're leaning more towards this. because this requires a bunch of receptionists who have no clue how the system works at all. And this requires people who really know what they're doing. This makes more money so you can hire more people to create, like, basically little offices with people answering phones constantly answering phones, not giving answers, but answering phones. This has people picking up the phone and giving you the answer when you call in. All right. I'll catch you guys a little bit later. You have a wonderful night. I will be back in about, give me 10 minutes. I'm going to see if the dogs have to go out, but then we will go ahead and get right to the video where I go live to answer questions that you might have. I will catch you a little bit later. Please remember to hit the like button and we'll go from there. Thank you so much, and take care of yourself and be safe. All right, guys, I'll catch you later. Bye-bye. Bye-bye.